This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. Thanks for listening from the four corners of the earth and who knows, maybe even another solar system.
Beyond.
That's right, beyond. Now cue the Twilight Zone music. Certainly appreciate it. Call me with your calls at 772-340-1590. Feel free to call at any time of the show. Interrupt me no matter what I'm talking about. It's okay. I welcome it. I try not to take myself too seriously. Law can be a very serious business, a very stressful business, and while
except in Washington, D.C.
Well, that's very true. Yeah, and while you can't really take light of a client's case because it's very important to them, at some point you have to have a relief valve. Usually that's at home. Oh, sometimes even on the radio show. Good relief valve. But one of the reasons I try not to take myself too seriously is because when the types of clients I typically deal with, come into my office, they are not the white collar, typically, six-figure income clients who are looking for a West Palm, Fort Lauderdale, Miami white shoe law firm with beautiful marble, and views of the ocean. They're not quite as accustomed to dealing with lawyers and usually don't want to be dealing with a lawyer. And so we try to make it a little bit more approachable to them. And hopefully those of you who are regulars in terms of listening here realize that I try to make myself a little bit, sometimes the butt of the joke. I don't mind. If it makes me more relatable and, eases the interpersonal connection, then that's good for attorney-client relationships and it's good for the client overall. So call me. Ask a question, a serious one, a ridiculous one. Sometimes the ridiculous one is really a very serious one. You didn't realize it. And very often the serious ones, there's no case. That's just because of the way the law is. Anyway, okay, so what are we going to talk about today? There is a topic which I've touched upon, maybe a year ago. It's amazing when I can say something like that a year ago. And I've had about 3 clients on this issue. I have one presently in litigation on this issue. And I believe I have another one coming down the pike. And that is the issue of what does one do if you own property, real property, with another person and you're not married and you want out and the other party won't
You're
sell.
A partner in this property?
Well, you could be a partner. It's really called either a co-tenant, a joint tenant.
Okay, gotcha.
I mean, you could be a quote-unquote partner with one other person. You could be a partner with 10 people. But a group, 2 or more people own a piece of property. So let's just say, it's the land on which WPSL is built.
Uh-oh, don't go there. Oh.
And one of the 2 want to sell it. And the other one refuses. So what happens?
This is getting a little close to home here, pal.
We can change the locale.
I wish you would.
Let's say 2 or more people own the land under 1600 Pennsylvania Avenue, and
that's much better.
A few million of them want to sell it. So what do? We got Bill on line 1, so what are you going to do is going to have to wait. Hey, Bill, how are you?
Hello.
How can I help you?
Okay, this has to do with a piece of property I sold to one of them people that say, I'll buy your property for cash and no closing costs and no all that stuff.
All the little signs that are sort of on every street corner.
Yeah.
Okay.
But when it came to the closing, they charged me closing cost, and I didn't realize that. I signed the papers, and then they send a check into the account that you give them after you've done all this.
Right.
And they charged me closing costs.
All right.
And I sued them.
Oh, you sued them. Okay.
No, can I?
Oh, can you sue them? Okay. How long ago was this?
January.
All right. Well, then you don't have a statute of limitations problem. Yes, you can probably sue them. I mean, one hurdle.
But how do I get their address? All I have is a name.
Well, Google it or look at. First of all, you can do it on your own by going to sunbiz.gov. I think it is .gov.
Yeah, Corporation Commission.
And you can look up any corporation by its name or its trade name, and usually you'll find out what the formal name is, who the registered agent is, and who at least the president or the chief officer is. If you can't do that, then it's ask a lawyer. And you call me or somebody else, and that's not too tough of an issue to figure out. What you'll be suing for is really breach of contract, and that would be for the difference, in the closing costs. One would have to read the contract you actually signed carefully and make sure you didn't sign something that got switched on you. If it hasn't been and it's there, it says no closing costs, and you got charged closing costs, you got a pretty good breach of contract claim. If they switched the language on you, then you have a hurdle. The hurdle is you are presumed to have read what you signed. So you may not have a very good contract action. On the other hand, you may have an action for fraud, which now is no longer contract, it's tort. So you may very well have a claim, and I would say you probably do need to consult with an attorney, depending upon where you're located, me or somebody else. Cheryl's certainly standing by to take your call if you'd like, because we have to look at the original contract, we have to look at the closing statement, and that way, most attorneys can figure out whether or not you really have a viable claim.
Okay, thank you.
You're very welcome. And I do believe we have another one.
Should he call the sheriff's office?
Well, no, they're going to say it's a civil matter now.
Okay.
Because closing has already occurred.
Gotcha.
And I believe now we have John on line 3 from Port St. Lucie. Hi, John. How can I help you?
Morning. Is this Trump headquarters? I'm not sure I dialed the right.
Oh, there ain't no chance that this is Trump headquarters. Not unless they've hired me as a spy.
I called you, I think, a week or two ago and
Okay.
mentioned that my niece in Maryland.
Yes.
I was talking to her the other day, and she said it's the company she worked for had a contract with it's called Teachers Annuity Insurance
Okay.
and annuity. She said that she can only withdraw 10% per year, and she still has about 7 years left.
Right. That is a federal regulation.
Oh, okay.
And that comes from somebody who doesn't know very much about this stuff. Yeah, depending upon type of annuity or type of retirement account you have to withdraw, once you get to a certain age, a minimum amount. It's calculated differently. I think it's based upon life expectancy. I'm not sure. I don't think there are restrictions, at least on the federal side, of withdrawing more. Now, the contract she entered into may restrict the maximum which she can pull out in any given year. And again, that's something that, you or some lawyer might have to look at.
She didn't directly enter in contract. She said the contract was between her employer and, the teacher's annuity.
So this was a benefit of her employer?
Yeah, but she discontinued from her job.
Right.
That she no longer has. You know what I mean?
Right, but that would still be governed by the policy document entered into between the employer and the annuity company because it was a benefit being provided.
Right. So I guess she's just stuck where she is,
Well, all depends upon what the documents say. See, that's what, I can never say somebody is stuck without actually looking at documents, because you look. This is why lawyers look at contracts. You find something in there that gives you the loophole, gives you the potential out, or gives you an easy, legitimate out, and that's the whole purpose of looking at a contract.
Yeah. I told her to try to reach a local lawyer. Maybe they could give her some advice reasonably. Or
yeah, I think that's an excellent idea, depending upon the amount of money at issue. Even if you have to go in for a paid consult to some lawyer, spending a few $100s is, I think, a reasonable investment to determine whether or not you can get at more money than they're allowing you to get at right now.
Sure. All right. I'll pass that along to her, and thank you for your advice and your help. We really appreciate it.
You're very welcome. So, folks, I've been asked on Facebook Live, just to sort of summarize, that was a call about an individual who had a benefit from the employer. It's an annuity, and they're telling her she can only take a certain amount out per year. And now the question becomes, can she take more out? And that is really going to be governed by the plan documents.
Now, she might also want to talk to the attorney for the school board, because don't they negotiate that?
Well, yes, and that's where she may get the plan documents. Usually your employer, even if it's a former employer, there's a plan administrator.
Oh, sure.
And so the plan administrator has to provide you with the plan, which has been approved by the federal government. In order for it to be an employee benefit under the ERISA statute, it has to have been approved. So you can get a copy of it. And from there, some people are able to read this and understand it. Others really say, well, let me just give it to a lawyer, because very often it's in legalese and it could be hundreds of pages, and the lawyer's trying to find the relevant section, and if you're trying to read a few hundred pages, it's easy to go down the rabbit hole.
Good luck. Yeah.
Anyway, so unless we get another call, which would be wonderful, at 340-1590, we were sort of talking about, well, what happens? You own a piece of property with somebody. You want your investment back, or the property's appreciated in value, and you want to lock in your gains. Or you bought the property with a boyfriend or a girlfriend, and the other one says now, no, I'm not selling, especially if they're the one now living in the property.
Uh-oh.
Happens all the time. The one living does not want to sell it, and certainly doesn't want to give you half the value of the property, and may not even have that kind of money, and that's why you have to sometimes sell the property. The cause of action is called partition. Now, that's not like a partition on your hard drive. Actually, in a way it is. What you do is, if you can't resolve it outside of court, a lawyer will usually write a demand letter first and try to get this thing negotiated before lots of attorney's fees are spent.
But boyfriend, girlfriend is not a legal thing anyway, right?
Well, it's not a legal thing, which is why if a boyfriend and a girlfriend buy a piece of property, they are tenants in common, each with 100% undivided interest in the property. And so each one of them can get out if they want to. Now, joint tenants, one dies, you get the whole property. You can buy it as joint tenants as well. But again, even a joint tenant has the right to partition. The only property that can be held differently is a marital property, which is held as tenants by the entirety. And there, you don't have the right to force it unless it's in the process of a dissolution proceeding, where they sort of go through a very similar process to partition, though it's slightly different.
But if you're getting a divorce, the divorce attorneys would...
Oh, yes, absolutely. They're going to handle that. Yeah. It's going to be part of the property distribution. So you have a lawyer do a demand letter, or you contact your ex or whatever, and they're not going to budge. Well, now the course is you got to file an action in circuit court for partition, which basically means, Judge, I have an ownership interest in this piece of property. I want out. The other one or other ones won't get out. won't allow me out, won't divide the property. They won't sell me my share of the interest at a reasonable price. And so either I want you to order the property sold and the proceeds distributed in the manner in which the court orders, or I want you to order them, determine what my value of my interest is, and order that either I be paid that amount or the property be sold to satisfy that judgment. That's a petition action. Okay? Now, I have run into the unfortunate assumption by people who own property with, let's say, one other person. We both own the property 50-50, so I want half the value of the property. That is only a starting point. It is not the end point. Between that starting point and the end point in determining who gets what are a lot of factors, a lot of considerations. They can be boiled down relatively easily, but then you got to engage in either discovery on them to determine who paid for what and what credits each person gets.
Isn't 50-50 just what it says?
Well, that's where you start. That's where you start.
Okay.
Okay? So let's say we have two people, it's 50-50. Now what happens? Okay. One person may have been paying the mortgage for 20 years. One person may have been paying all the property taxes. One person may have been paying all the homeowner's dues. One person may have paid for all the improvements or repairs. Get my drift? Okay.
Yeah.
That person is going to be entitled to what's called a disproportionate share of the partition. How much? That's something you either battle over and negotiate, or you battle over and a judge decides after a trial.
Well, if you've been paying the payments for 20 years, that's a lot of money.
It can be. And so in a partition, it may be that one party ends up getting 80%. All depends upon how much has been put in by each party and what is considered equitable under the circumstances. Because again, that's only one factor. So let's just look at generally what the factors are. First, we got to calculate the proceeds of the partition sale, because we're going to start with the 50-50 assumption. So the general rule is that each co-tenant is ultimately liable for his or her proportionate share of the obligations and expenses of real property. The rationale is that the equity of one co-tenant should not be increased by expenditures of another. So you put on a new roof. It increases the property value by 10 grand. I now sue for petition. I shouldn't be entitled to an extra 5 grand because you paid $10,000 to put on that roof.
You should or shouldn't?
I shouldn't. You were the one who improved the property.
Okay.
So I shouldn't be getting a benefit out of that.
Oh, I got you. Okay.
Okay? So we start looking then upon a partition. A co-tenant who has been paying more than his or her share is entitled to a credit from the proceeds of a sale against the other tenant's proportionate share. Again, we're still at 50-50. But now the 50-50 is going to begin adjusting. So what are the considerations? Well, first, each party's proportionate share must be determined by using each party's percentage of ownership. So let's start with 50-50. All right. Now, second, the court must then decide which household expenses are reimbursable. The most common ones are necessary to preserve and maintain the real property: mortgage, taxes, insurance, association fees, maintenance, replacement, repairs that need to be made. So then you start looking at, okay, the property's worth $100,000. Each party started out with an entitlement to $50,000. The first co-tenant put in extra $20,000 for these items. Well, now he's going to get a credit against the $50,000 the other one was entitled to. Now he's at 70 and the other one's at 30. So we're beginning to move the ball. Okay. Second, the court must decide which. Well, that was the household expenses. I'm sorry. Third, there must be a determination of the amount and the percentage of expenses that should be reimbursed from the non-paying co-tenant's share. Now, in a personal relationship outside of marriage, the analysis begins from the date of the original closing to the date of a trial. So, if one co-tenant pays 100% of an obligation for which they should be jointly responsible, then that co-tenant has a credit against the other co-tenant's share. If one of them made a down payment, well, they need to get credit for that down payment, and that may go back the other way. This is all a mathematical football that gets thrown back and forth. So if we have that, we're at that 70-30. But guess what? It's the other person, not the one who's been paying the mortgage, etc. The other person put down $30,000 as a down payment on his home, without which the home could not have been purchased. Well, now they may be getting $15,000 back in their ledger. So now we're up to 55-45.
Oh, man. Okay.
All right, it's like a football game. The other side has the ball now,
Oh,
and
yes.
we're inching back. Okay? Fourth, the real property must be given fair market value. So, let's say we're at the end of a trial. The property hasn't been sold. You got to make the calculation from not what was paid for the property, but what is it worth? Hopefully it's worth more.
So you get that from the appraiser's office, right?
Well, no, because the appraiser's office isn't really appraising the market value.
They aren't?
No, never. The appraiser's office is appraising taxable value. Okay, so how the county is going to apply the taxes. Always much, much less than what the real value of the property is. So you get that either from real estate experts, or if the parties agree, go to Zillow, go to realestate.com, go to Redfin, go to a host of others, agree to average them. If you can all agree on something, then you agree upon the property which we bought for $100,000 is now worth $300,000. Okay. So now the 50-50 starts at $150. And the deductions, which initially seemed so great, that got it to 70-30, well, they make a smaller dent in what the other co-tenant is not going to have to give up. And then you start thinking, they paid the down payment. And now you start going the ball back the other way. So now you may be at a situation where, let's say it's 2/3, 1/3. Okay, $200,000 for the one co-tenant, $100,000 for the other co-tenant. Well, the $100,000 for the other co-tenant may not be so bad if they bought the property for $100,000. That's still a pretty good success. So the goal in these actions is to, because they get to be sort of like marital dissolution actions, really, fighting over real property. And the goal here is to figure out, beyond all the swearing and the statements of I paid for this and you never paid for that and you never paid for anything. Well, now that's the lawyers have got to figure out what the truth is, so that if necessary, we can present it to a judge at a trial, or a mediator at mediation, or even now, armed with the information, the two attorneys can negotiate back and forth.
Dare I ask how long this football game takes?
Well, if we can resolve it without litigation,
Okay.
it could be over in a couple months. Like anything. I mean, I can send a demand letter for sexual harassment. It could be over in a couple months if we can reach an agreeable settlement. But when you can't agree and when litigation becomes necessary, of course, there can be a settlement at any moment, at any stage of the proceedings. But if you're talking how long does it take to get to the trial, you're talking somewhere between 12 and 24 months.
Oh,
That is our circuit civil system here.
whoa.
In some ways it's better some other places. In a lot of ways it's worse than other places. And I've said many, many times before, we have a situation, on the Treasure Coast, we're not alone, where for the most part we have one circuit civil judge in a county. If we're lucky, two. one for jury cases, one for non-jury cases. Why do we have 1 or 2 and criminal law has 10? Because criminal law deals with constitutional rights, the right to a speedy trial. When you're dealing with constitutional rights, you may need more judges to make sure that they're satisfied. And so the stepchild becomes the civil case. And that's just the way it is.
Is it like that everywhere?
Well, it is like that almost everywhere as far as I know. But that doesn't mean, a larger county, for example, like Broward. I've been to the Broward courthouse many, many times. Maybe they have 50 criminal judges and a dozen civil judges. So they're still going to have a lot more criminal, but they have a larger population. They have a larger allocation of budget for judges. And so you may not be stuck with 1 or 2 circuit civil judges. You may have a dozen. Now, does that mean it goes any faster? With certain judges, probably. But with the average judge, it's probably going to be about the same because they're going to have about the same caseload.
But waiting to sell a house 2 years is ridiculous.
Try getting a divorce.
Okay. Oh, man.
We can only do what we can do. Trust me, I have called to set hearings where I need 30 minutes of the court's time, and I'm told we have an opening 3 months from now. It's like, what am I supposed to do? Am I supposed to stop work on that case for 3 months? Well, no, if this motion can be done sort of compartmentalized, and I can continue on other aspects of the case. But if this motion is like a prerequisite to me being able to go to the next step, then we're stuck. And explain that to a client. Well, no action is going on for 2 to 3 months. No matter what you tell the client's not happy. So, all right, so we're at a point now where we know how the distribution is going to be calculated. We can't agree upon it, so we enter the dreaded discovery phase. So what types of discovery am I going to do? Well, this morning I decided to pull out from one of my cases one of my requests for production of documents because it helps to show what factors are important in a partition action and what you're going to try to find out. That's my little thing yelling at me for whatever reason. Excuse me. Shut it off. Well, one of the things I ask is, I want all communications, emails, text messages, phone records, letters, between the 2 parties that have to do with the real property. I want everything.
Okay.
Because who knows in what there may be an admission. Who knows in what one party may have discussed, well, you're putting up $20,000. I agree that I'll pay you back. Never know what you're going to find. I want it all.
Okay.
Next thing is, well, communications with any third parties that have to do with the property.
Like what, banks?
Like
or
the
something
bank,
like that?
the realtor, the other owner's mother. Who knows? Again, this is one of those, lawyers are fond of objecting to discovery and saying, it's a fishing expedition. You're not allowed to go on a fishing expedition. Do you know there's case law in Florida that says, yes, you are? Judges routinely say, motion on this denied, it's a fishing expedition. They may be right in their reasoning, in their ruling, but they're wrong in that reasoning because fishing expeditions are allowed. Now, how far can you fish? Maybe it's only the 2-mile limit, not 200. That may be where a judge is right to say, I'm not allowing this particular piece of discovery. But to say I'm not allowing it because it's a fishing expedition, I sort of have in my back pocket 2 or 3 Florida cases that say fishing expeditions are allowed, and I love quoting them because it creates a whole big uproar.
And the judge is not happy.
No, usually not happy with me. They find another way to rule the same way.
Naturally.
All right, so next, I want records of all payments that were made by one party to the other party with regard to anything having to do with that real property. Acquisition, improvement, repair, taxes, mortgage, insurance.
If you've been in that house 20 years, where in the heck are you going to find records like that?
You get them recreated.
Going back
Banks.
20 years. Really?
Yes, you go get them recreated.
Okay.
If you haven't kept them all, that's wonderful. Either go get them recreated or show enough of the pattern that your attorney, whether it's me or the other side, feels comfortable in arguing to the judge that this shows essentially the history and we can't go any further back. But my testimony is it was the same. Okay, that's still evidence. Testimony is evidence. As a lawyer, I like documents better because then you don't get into he said, or he said, she said, or she said, she said, or she said, he said, or any of the other variations. So now I want the bank statements. I want canceled checks. I want receipts. I want invoices. If you said that a rabbit, let's say a beaver ate through your attic, and so you had to repair the attic so that other varmints weren't getting in, and cats weren't having babies in there. Trust me, I had that happen in my old house. That's a reasonable repair. You make that repair, that is a necessary repair. You, on the other hand, decide, well, I want large marble columns in front of my house so it looks like a palace. That expense is probably not going to be accepted by the court as being a legitimate expense, where the other co-tenant has to share, half of that.
When you get it through the HOA anyway.
That's right. So, I'm looking for those types of things, and so is the other side. Depends upon which side you're on in terms of whether you're claiming, you're entitled to the full 50% and the other side is claiming, well, I did X, Y, and Z, I should get more, or whether it's the other way around. And in this respect, trust me, lawyers go both ways. You take whatever case comes into the office. All right, so what else? I want copies of all contracts that were entered into between the parties and any other party. Let's say this property has been rented for a period of time. I want the leases. I want the payment records. I want to know how much over the mortgage, et cetera, has been received. Because if it's been received by the other side, I'm going to assert a 50% interest in that. It's profit.
Sure. Yeah, that makes sense. Yeah.
I want, of course, all the documents that relate to the actual purchase of the property. I want photographs, videos, other electronic or photographic materials that will tell me everything from the beginning of the property until now. Because then I'm going to be able to track changes in the property, exterior and interior, depending upon how many photos and videos I get. And so if my client is saying, well, I improved the living room by putting in a wall unit and putting in new lighting, and it has increased the value of the property, and I have a before and after picture, well, that's certainly going to help my argument that that particular client is entitled to some credit against the other side's share, the other side's interest. I want all documents that show any of the damages that the other side is claiming. I want to know what they're claiming so I can figure out whether they're going to be entitled to a credit or not. or whether or not I should be battling it. I want documents that show whether they mitigated their damages. They needed a new roof because of the hurricane. Instead, they left a tarp on there for 5 years, and then everything caved in, and now they had to spend $100,000 to fix the house. Does my client have to pay the $50,000 co-share? No. If they didn't mitigate their damages from the hurricane, and they left that tarp up there way too long, that's their problem, is my legal argument.
Whoa, okay.
Okay?
Yeah.
Any documents that relate to who took what income tax deductions?
Oh, come on. Gee, many Christmas.
And let's just say for now, any other documents that might show an explanation as to why one party or the other is claiming an entitlement to a disproportionate share. That's what's called a catch-all. If all my other requests haven't covered every particular situation I could think of, there's that catch-all. And so if the other side knows something and it's material and they don't produce it now, I'm going to be screaming bloody murder at trial. So where are we right now? Well, first of all, both parties have paid a lot of money to their attorneys. All because of this dispute, which makes it much more rational to try to resolve these types of disputes before suit or early in. Because depending upon the value of the property, each side's proceeds may start getting eaten away by attorney's fees. Now, can anything be done about attorney's fees? Yes. One of the things that the court can ultimately determine is how much of attorney's fees were reasonably incurred in seeking their share and can then make adjustments.
Doesn't the loser pay the attorney's fees?
No, not necessarily all of it.
Oh,
and even if it was all of it, then a good attorney is going to start attacking my billing records as excessive, unreasonable. I'm going to do the same thing to theirs. And a judge is going to have to decide what's rational, what's reasonable. You know, I had a judge, for example, he's no longer on the bench. A federal judge, a magistrate judge in Fort Pierce for what seems like a lifetime. And I had a case where I won attorney's fees. So now it's up to this magistrate judge to make a report and recommendation to the federal judge as to what I should receive. And as part of that, I file a motion. I give all of my billing records, which shows everything I've done on every day, every hour, every tenth of an hour. And has my billing rate. The other side doesn't make a big argument about, oh, this was unreasonable, that was unreasonable. They argue that my hourly rate was unreasonable. And I respond essentially in writing in a much more professional and dignified manner. Yo, judge, this is my regular billing rate for an hourly case in federal court, and it is in the middle, essentially, of what attorneys in this county charge for similar work. Seems like a great argument to me. This judge cut my fee request like by 2/3, and I was incensed.
So there's a different rate for federal court than there
A
would
lot of
be
lawyers,
for circuit?
Yes.
Really? Okay.
Federal court, I enjoy it more, but it is more difficult.
Well, I think that would be kind of fun. It's more challenging, right?
Costs more.
Yeah, I bet it does.
So why did this federal magistrate cut my fees by 2/3? I couldn't believe it when I read it in writing. I can almost quote it to this day. You got to understand that our federal court here, the Southern District of Florida, runs from Key West to somewhere north of Melbourne. That's the Southern District of Florida. And within the Southern District, you have, let's call them divisions. Some people call them vicinages.
What? Can you say that on the radio?
Vegemin.
Oh, certainly.
I love Lucy. So you have Key West division, you got the Miami division, you got the West Palm Beach division, you got the Fort Pierce division. Okay. And this magistrate judge, in my opinion, had the audacity, the unmitigated gall, to actually write that attorneys in the northern vicinage of the Southern District of Florida cannot expect to receive the same hourly rate as attorneys in Palm Beach or Miami.
Ooh.
Why?
Ouch.
We're doing the dang same work. If we have the same dang qualifications, I've been a lawyer for over 30 years. There were solo practitioners in Miami. There are solo practitioners in West Palm. Why do they get more than I get? I've never heard another judge make that argument. So this magistrate judge cut me by like 2/3. It hurt. It was bloody. I had to go to the emergency room. Had to patch me up. Now, so what can you do in that situation? You file what are called objections to the report and recommendation of the magistrate judge, and it goes to the federal judge. Now, federal judges are really, really busy. And the whole reason of having a magistrate judge is to save them work. So anytime they get objections, they're not too happy in the first place.
Now, this is a federal judge, not an appeals judge.
This is a federal district judge.
Okay, gotcha.
Okay? The judge that was on this particular case. You know, it's not really fair, but you could say the magistrate judge is the helper judge. So now, there are federal judges who do reverse their magistrates. I've had them. I've had federal judges on discovery motions say, nope, sorry. Magistrate judge said, no, you're not entitled to this. I'm saying you are. Wonderful. It got looked at, in my view, fairly. Even if the federal judge said, no, I'm not going to reverse it, if there's an analysis, even if I disagree with it, but I see a real honest-to-goodness legal analysis, I can live with it. But when a federal judge, as often happens, rubber stamps the magistrate judge because they don't want to look at it, well, that's not fair. That's exactly what happened in this other case. You know, I got my bath, and my only choice now would have been to appeal to the 11th Circuit. That takes time and money, and it's not coming out of the client's pocket. It was an attorney's fees issue. So if I'm going to do this, I'm funding it. So I tell my clients, I don't care that there's an attorney's fees provision in a statute. Do not count on it. Don't make part of your calculation, I'm going to get my attorney's fees back. Assume that whatever you pay me is lost money, because that is the better way to evaluate any potential settlement offers.
Dare I ask how many decades ago this was that you remember every detail?
It was less than 1 decade ago.
Wow. but still vivid.
That judge is retired.
Vivid in your mind.
Very vivid. So, you know, summary of partition, which has taken us a good part of the hour, which is fair. Because, like I say, I've had 3 cases. I got one now in litigation. Got another one that looks like maybe coming down the pike. It's not an uncommon issue. You get into any type of dispute with anybody who you own property with. This is the recourse that you have if you cannot resolve it on your own. And these are the detail, the minutia of things lawyers are going to look at and demand. And the other lawyer is going to be demanding it of you to try to determine what a fair share is. We start out at that proverbial 50%, but it rarely ends up there. And I think we have another call. We have Andrew from Jensen Beach. Hey, Andrew, how you doing?
Hold on a second. Let's see. Try another line. Not there either. Try another line.
Andrew, you there?
There we go. He's on one. Okay.
Hey,
now
Andrew,
we
how are
got
you
it.
doing?
Very well. It could be better. Just a quick question.
Sure.
This is my situation. I had a truck, my work truck, stolen out of my driveway about 2 weeks ago. All right. I filed a claim as soon as I noticed that it was missing with the sheriff's department. And I called my insurance company to tell them of my situation and have that truck's VIN number dropped off the policy.
Okay.
Okay. Now, I kept on inquiring on how the investigation is going. I'm getting no response. That's okay. Now, finally, I got a hold of the legal department of the insurance company, and I explained my situation. I know I was at fault. I left the keys in it. All right. I will admit that fine and clear. Okay. Now, since I filed a case number with the sheriff's department and informed the insurance company of the situation, according to the legal department of the insurance company, that if that truck is ever used in committing a felony or an accident, I'm still liable. Now, my next final thing is I still have the title. It is free and clear. Would you advise me to take the title down to the DMV and say, no, void, this truck does not exist anymore? I mean, what do you think I should do?
All right. I can give you broad contours because this goes a little bit beyond my area of practice and experience.
Sure.
Sure. I can tell you that red flags go up when you tell me that legal told you that you're responsible if the truck's involved in any felony. That
Right,
sounds like baloney.
Right, because the first thing that popped out of my mouth when their legal told me, I said, "Isn't there a statute of limitations?"
It's not even
that.
I mean, it's that you reported the car.
And he said no.
You reported it
and he
stolen.
said, "No, this goes on for this will go on forever." And I don't believe that.
You probably need an attorney that deals with insurance law and
Okay.
to answer that. But that sounds fishy to me.
Yeah, and I'm telling you the truth. And I mean,
I believe you're telling me the truth, but I believe that whoever told you that from the legal department, that sounds fishy. It sounds like it's in the insurance company's best interest to have you believing that and accepting it, and I don't necessarily believe that's accurate.
Okay, because attorney address, I'm not really looking to be reimbursed for the loss of the truck.
Well, why not? Whoa. This is where if you call a lawyer, the lawyer steps in. Why not?
Well, the problem was on that truck, I did not have comprehensive coverage, therefore denied. So.
Okay, so you didn't have comp coverage on the truck.
No, I did not. I had just a little bit above PIP. So, that's where I stand.
All right, I hear you.
I'm just concerned about that truck. Whoever stole it commits a felony with it or gets into an accident, and I'm still on the hook in the sense, Well,
I think if you've canceled the insurance, I don't see how you can be on the hook for an accident. I don't see how you can be on the hook for criminal activity that you're completely uninvolved in. The vehicle was stolen from you. You reported the vehicle was stolen to both the police and to the insurance company. Just my basic knowledge of law tells me there's something wrong with that.
Yeah.
And so, as a lawyer, I'm suspicious, I'm doubtful, and if you're concerned about that, which I certainly understand, I would say to, maybe call the local bar association, and see if they can point you towards an attorney who deals with more insurance litigation.
Okay. Also, too, do you think it would be relatively a good idea to take the title down to the DMV, explain my situation? I can show them the actual case number documents stating that this is the thing. I want this truck stricken from the records from the Department of Motor Vehicles.
I don't know how to answer that because what if the truck's recovered tomorrow, and what if it's in good condition? Don't you want it back?
Yeah, see, that's the pickle.
Right. So I don't think that taking the title and saying I'm washing my hands of this is the answer. So I think you probably need to do a little bit more investigation because I don't see giving up all your rights to it in case it's found one day.
Okay. Hey, oh, the angst is killing me.
I hear you. I understand.
That's okay, but that's cool. Thank you, Attorney Address.
You're very welcome.
I truly appreciate your giving me your quasi advice in regards
That's
to
what I'm
my
here for. I help
situation.
where I can, and where I'm not really sure, I'll tell you that.
Oh, I listen to you every Friday.
Thank
man.
you very much.
You're
I
on the ball.
appreciate it.
All
Take
right,
care.
You all have a great day.
Have a good
all right,
weekend.
bye.
Captain Quise.
Well, I guess what, we're down to a couple minutes.
Yeah, that's tough because he left his keys in the
So
truck.
should I sing for my supper?
Yeah.
Or should I do what they say, like stretch?
Well, I just don't even know, going back to that old case of yours, that what was a 50-50 ruling is a little strange.
Well, I will also tell you in these partition actions between ex-boyfriends and ex-girlfriends. My sister says, no, I should not sing for the supper. Between ex-boyfriends and
Please
ex-girlfriends, things get down to such nitty-gritty. I paid for this $8 thing because they can be as nasty as a divorce action.
Well, there's emotion involved.
That's precisely right. And so both attorneys need to hopefully separate themselves from their client's emotion and try to help steer them to a rational, reasonable resolution as expeditiously as can be done before both sides spend a ton of money and the only winners are the attorneys, which is why the public so hates us when they perceive that we're the only winners. And, I can understand that actually. So, when my clients paid me a lot of money and I'm looking at the case and I don't think it's the greatest in the world anymore, I try to find a decent way out for them where they can recover as much as they can recover and still maybe not be thrilled, but it's a lot better than paying me double to get them to a trial and lose. Well, we are winding down, and so I can say to you, Cheryl is bored. It's a Friday. I'm not in the office. She really has very little to do. I haven't given her many assignments. Give her a call, 781-8003. I can guarantee you she has nothing better to do than to chat with you, and I think I may get my throat slit on Monday.
You probably will.
Have a wonderful weekend. I hope the rain keeps away for most of it. Enjoy yourselves, and if you need to ask a lawyer, either call my office or give me a call on Friday next week. Take care. Bye-bye.
And maybe we'll see you back if you survive
Right.
your paralegal.
If I survive my paralegal.
This is WPSL Port St. Lucie.